Welcome to the Contract Law 1 course at the Faculty of Law of the University of West Indies, Cave Hill. Today's lecture is on acceptance. Now, we recall from the offer lecture that an offer has to be definite. That means it must be clear as to all its terms in order to be capable of being accepted. Now, by implication, that means that the acceptance itself must be expressible by a simple I agree. Just those two words, I agree. If an offeree has to say more than that, if they, for instance, have to say, I agree if, or I agree in case that, if there's any need to say more than I agree, then the contract is not fully formed, because what sounds like an acceptance, I agree but, or I agree if, is not actually an acceptance. And the reason why it's not an acceptance is because it is not in identical terms. An acceptance has to be in identical terms. What that means is that it has to agree to all the terms of the offer and not amend them, not change them in any way. And that's really the essence of what acceptance is about. So if we apply this in form of a test, we can always ask ourselves, in terms of what an offer looks like, we can ask ourselves, is it possible to say I agree to an offer? If it is, well then the contract would be formed as soon as those words I agree are stated. Now, of course, that also means that the offer itself has to be definite, and has to be definite in the way set out in the contract lecture. Specifically, it has to comprise the four elements. That is, it has to be clear who the parties are, it has to be clear what the subject matter is, it has to be clear what the reciprocation is, and the time frame also has to be clear. Now, these things may not be expressly stated. For instance, if you go to a shop and buy something, you buy a snack and you hand over the money and the contract is formed at that point in time, you would not necessarily or not normally say, I would like to take my sandwich or my snack right now, because by implication that is what you're doing anyway. So you may not have to express all the four elements of what a definite offer is each and every time, because in most cases at least some of them are fairly clear. The price may be clear because the price is marked, the parties are clear because you're the one who is in the shop, and so on and so forth. But as a general rule, of course, we need those four elements to an offer, either expressly or by implication. And if we have them, and that means the offer is clear and it is a definite offer, then it is possible to say, I agree. And those very simple words, two words, I agree, mean at that point in time, the contract would be formed. Now, we had the case of Harvey and Facey, and Harvey and Facey was for the sale of Bumper Hall Pen, sale of a property, and there was an exchange of communication between the parties. And you may recall that the seller, in that case, put forward a price at which they would be willing to sell, but they did not stipulate to whom they would sell. So in terms of the offer, it was missing one of the elements. It might have been missing more than one, but it certainly was missing one, namely that it was not clear who the parties were, because it was not clear to whom the property would be sold. And because of that, it was not an offer that was capable of acceptance, namely by saying I agree or I accept. Hence, no contract was formed. Another rule that we need to bear in mind is that you can only accept an offer that has been communicated. Now, usually that's not really a problem, because usually you would hear an offer, it would be directed at you, and then you could decide whether you were going to accept or whether you were not going to accept. But in Re Clark, something a bit strange happened. There was a person, possibly a criminal, likely a criminal, and he had some information on a murder, and he knew who the murderer was. Now, in order to protect himself, he told the police who that murderer was. It then transpired that there was actually a reward for naming the murderer, and so then the informant tried to claim that reward. And it was held that the reward was not claimable, in this case because the offeree had not said or laid the information or come forward with the information in order to claim the reward. They had done so to protect themselves. But what we can take from this as a general rule is that you need to be aware of an offer in order to accept it. It had to be directed at you in some way or form. And so this moves on to the last point that you have here on the PowerPoints, that we can only accept an offer if it was addressed to the offeree. Now, there's no case there, but I'm sure you realize already at this point that a case we could use here is Carlyle and the Carbolic Smoke Bowl Company. Because of course in that case, the issue was that Mrs. Carlyle may not have been an offeree, because the Carbolic Smoke Bowl Company said that they had just put out an advertisement. They had not put out an offer that was addressed to Miss Carlyle. Now, in the circumstances of the case, as we discussed as part of the offer lecture, it became clear that indeed she was an offeree and the offer was capable of acceptance, namely by doing exactly what the offer stated, which is what she did. But as a general rule, and so Carlyle is a bit of an outlier, as a general rule, we can take from it that you can only accept an offer if it was addressed to you, the offeree. Now, when we look at acceptance, there are a number of rules, so let's try and look at them one by one, and some of them may be quite specific, but these events do happen from time to time, and it is, of course, important to know what the applicable rules are. First of all, cross offers are not acceptance. What are cross offers? Basically, cross offers are offers that cross each other. So what happened, for instance, in Tin and Hoffman is two parties, a buyer and a seller, were negotiating about the sale of iron. And what happened was that the buyer sent off a letter to the seller putting forward or proposing to buy iron at a certain price, at a certain quantity. And the seller, at the same time, also posted a letter to the buyer offering to sell that amount of iron at the same price. So it happened to be exactly at the same price, same amount. So in essence, both parties had exactly the same thing in mind. There was total agreement in what they wanted to do with the contract, what it was going to be for. There was even total agreement as to who the parties were, obviously. So everything seemed set. But what was missing was that neither of the parties actually accepted. Neither of them said, I agree or I accept. What they both had done is they had both made offers. The buyer had made an offer to buy and the seller had made an offer to sell. And so these two offers had crossed in the post, hence cross offers. Now, even though they are identical offers, they do not amount to acceptance. So for acceptance to be valid, you have to actually say those words or act in some other way that makes it clear that you have in fact accepted. So two offers do not make an acceptance. Equally, counter offers do not amount to acceptance. So you'll recall in the case of Hyde and Wrench, we had a price that was put forward, and then the reply was that that was too much and a lower price was put forward. So that's a counter offer. And as we learned in the offer lecture, a counter offer destroys the initial offer. So when the buyer afterwards changes his mind and says, well, I'll take the original price that you had put forward, the seller is no longer obliged to go ahead on that basis because their offer had been destroyed by that point, namely because the seller had put forward, I think it was £1,000. The buyer said, how about $950? And at that point, the buyer had destroyed the original offer of $1,000. So when the buyer came back later and said, all right, I've changed my mind, I'll pay $1,000, well, the seller can still go ahead and accept, but that would be a new offer altogether, or a counter offer, or the seller can say no, because the original offer made by the seller initially was destroyed by that point in time. There's also something called the Battle of the Forms. And in order to understand what that is, we can look at the case of Butler Machine Tool and XLO. What happened in this case was that a company, Butler Machine Tool, was negotiating with another company, XLO, to sell machines. That means Butler Machine Tool was the seller and XLO was the buyer. Now what happened was that Butler Machine Tool sent their offer to XLO, and their offer included a price. And these were expensive machines. These were in the tens of thousands of pounds. And the price was acceptable to XLO, but what was not acceptable was that the sale was to happen on the terms and conditions of Butler Machine Tool. One of the terms and conditions of Butler Machine Tool was that although the price had been quoted, I think at something like £75,000, Butler Machine Tool reserved the right to adjust that price depending on market fluctuations and things like that. So XLO didn't like that clause, even though they were happy to pay the $75,000. So what XLO did is they replied and said that they would buy the machines at $75,000 on their own terms. That means on XLO terms. So here we have a battle of the forms. A form issued by Butler Machine Tool with a set of terms and conditions, and another form issued by XLO on their own terms and conditions. So there's this battle between those. And what happened when Butler Machine Tool received the letter from XLO, the one that said, yes, we agree to pay $75,000 on our own terms? What Butler Machine Tool did is they tore off the reply slip, which the XLO form had, and said they agreed. So at that point in time, if we just look at the classic offer and acceptance analysis, the contract was fully formed. That's because XLO had put in an offer, in this case a counter offer, because it was not in identical terms. The monetary amount, $75,000, was the same, but the conditions were slightly different. One was on Butler's terms, the other one was on XLO's terms. So XLO had put forward essentially a counter offer with agreeing to the price and doing it on their own terms, on XLO's terms. By replying or by filling in the reply slip, Butler Machine Tool at that point accepted those terms and the contract was formed on XLO's terms. Now, what Butler also did is they included a letter with the reply slip, and the letter stated that the contract would be on their own terms, on Butler's terms. But ultimately, that wasn't relevant anymore because the acceptance was the signing of the reply slip. And by that point in time, once that had happened, once that had been communicated to XLO, the contract was fully formed. So when there was a price variation in the end, and Butler Machine Tool asked for more than the $75,000 and XLO refused to pay, the whole matter went to court, and the court agreed with XLO that the contract had been formed on their terms. And so this is one of these cases that, as so many of the ones we discuss, that involved Lord Denning. He came up with his own analysis. It's a fascinating judgment if you have the time to read it. And one of the things that you'll see there is the notion of the last shot. He who puts in the last shot is the one on whose terms the contract is formed. So in this case, of course, XLO was the party who put in the last shot. That means they put in the last form, which was not then objected to. Now, you could argue it was objected to by this letter that was enclosed, but the point is that the actual reply slip agreed to XLO's terms. So this is called battle of the forms. Sometimes, especially in complex commercial transactions, the negotiations are very prolonged and there's a lot of back and forth. So sometimes we then try and piece apart where was the final offer or counter offer and where is acceptance. And so clearly here the acceptance was filling in the slip. So now that we know what acceptance is, namely fully and completely agreeing in identical terms with an offer. So acceptance is not a cross offer, it's not a counter offer. Acceptance is simply saying, I agree, I accept. So now that we know what acceptance is, we move on to the next basic rule, which is that acceptance must be communicated. Now, what's meant by that? Well, what's basically meant by that is that you have to, in some shape or form, communicate your acceptance. So we really talked about saying I agree. So orally accepting, that is of course perfectly possible and happens all the time. You can also accept in writing. You can accept by signing an offer, including terms and conditions of that offer. You can accept by sending someone a letter. You can accept by sending someone an email, a fax. All of those are absolutely feasible, possible, and it happens all the time. But it's also possible to communicate your acceptance by way of conduct. So simply by doing something, you may sometimes be deemed to have accepted. And so this is what brings us to a case called Brogdon and Metropolitan Railway. This is a very significant case because it basically established that acceptance might be done and communicated by way of conduct. What happened in that case was that Brogdon, who was in a partnership of 3 people, supplied the Metropolitan Railway with coal. And this was done on an informal basis. And at some point the parties thought it would be better if they formalized their transactions, their relationship. So what happened was that the Metropolitan Railway put forward a contract with some terms and conditions, or they put forward an offer anyway, which then may or may not have been accepted and hence may or may not have resulted in a contract. And Brogdon signed it. Now, the whole story is perhaps a bit more difficult than that, and there may have been some variations, but in essence what happened is that the terms put forward by the Metropolitan Railway were signed by Brogdon. And that's the important part for our purposes. Because as it turns out, Brogdon was not authorized to sign on behalf of his partnership, because after all there were other people involved as well. Now, as we shall learn later on as part of this lecture, anyone who accepts must of course be authorized to accept. So that was not the case here. So the question arose whether the parties had a contract nonetheless. So the court looked at the situation, and the court found that based on the facts, once these terms had been put forward and Brogdon had signed, what actually happened was that the parties kept doing their business, they kept doing their transaction, namely delivery of the coal, payment of the coal, and so on, and this was all happening on the terms that had been put forward by the Metropolitan Railway. So you could say that in practice, the parties were doing exactly what they had promised to do under their contract or under their ostensible contract. Because remember, we're still trying to figure out whether there was a contract or not. So since signing the document, that means the written communication, could not have been the formation of the contract simply because Brogdon wasn't authorized, how else could the contract have been formed? And what the court held was that the parties, by their conduct, had formed the contract. That means because Brogdon did exactly what was stated in the ostensible contract, by their conduct, delivering the coal, they had accepted and the contract had been fully formed at that point in time. Here's how Lord Blackburn put it. I've always believed the law to be this, that when an offer is made to another party, and in that offer there is a request, express or implied, that he must signify his acceptance by doing some particular thing, then as soon as he does that thing, he is bound. If a man sent an offer abroad saying, I wish to know whether you will supply me with goods at such and such a price, and if you agree to that, you must ship the first cargo as soon as you get this letter, there can be no doubt that as soon as the cargo is shipped, the contract would be complete. So of course, in this obiter, this hypothetical scenario put forward by Lord Blackburn, basically the offeror is putting forward the terms under which the contract could be accepted and also stating how acceptance may occur, namely through conduct. So it establishes here by obiter, but in the case of Brogdon, very specifically in real life through the actions of real parties, that if you conduct yourself in accordance with an offer that had been put forward, then your conduct shows that you have accepted and the contract has been formed at that point in time.